Nothing?
Nothing.
What does that mean? The show is about nothing.
Exactly. This video, like a Seinfeld episode, is really about nothing, because there is nothing I can tell you about legal positivism that you don't already know. Because everything you think law is, everything you think law does, and everywhere you think law comes from, you get because you're thinking like a legal positivist. That's how you were trained. Progressives, reactionaries across the political spectrum invariably see law as the product of state action. The validity of law depends on its source. Law is something you can describe. It's factual. It just is.
This is this. This ain't something else. This is this. From now on, you're on your own. Huh? This is this. What the hell's that supposed to mean? This is this.
If I tell you Congress passed a law, you accept immediately that the words on a piece of paper stamped law have the force and effect of the words set out on that paper. The rule of law is the rule of words. That's a powerful idea, but it's also relatively new. Only modern people think that way. It is really a mind-bending assumption if you think about it. A word on a piece of paper can control your life, allow people to come onto your property, empty your bank account, seize your passport, or put you in jail. No natural law thinker and no simple peasant a few centuries ago would have accepted that. Law used to be full of real checks and balances, not like the relatively superficial separation of powers described by the French writer Montesquieu. Before legal positivism, if you wanted to know the law, you had to go to many places, including your own conscience. You had to ask whether the words on the piece of paper were truly laws. You needed to consider the customs of the land, its traditions, moral principles, religious beliefs, what the elders thought, what the oracles foretold. Yes, you also did have to look at the occasional acts of the legislature or decrees of the king, and of course the decisions of judges, as in the case of the common law. The English Parliament was understood to have an immense power, but even critiques of the English system, like Jean-Louis de Lolme, who was from Geneva, could say Parliament can do anything or everything except make a man a woman or vice versa, which is another way of saying there were natural limits. Those limits were accepted. In 1600, if the King of France or a parliament decreed that a man could be a woman, no one could have accepted the decree or law as having any force and effect whatsoever. Natural law thinkers like a Cicero or a Thomas More would agree that a law that violated the laws of God or morality or even logic, or was long and confused and impossible to understand, would not be a law at all and had no force and effect. We can trace legal positivism to the Renaissance and secular studies in science and humanism. Renaissance and then Enlightenment thinkers wanted the world to be run rationally and scientifically, using the empirical method. It wasn't long before thinkers started to suggest that law too could be subjected to scientific analysis. The tendency of legal positivists, like a John Austin in the early 19th century, was to proclaim the autonomy of the law and to assert its right to be treated as a science. Law could then evolve scientifically. Until the 18th century, there was no clear line drawn between the physical laws governing the universe and the laws governing human behavior. Philosopher David Hume pointed out that you had to be clear about two types of inquiry: facts, or the what is, and standards of conduct, or what ought to be. Norms are the standard creators. He argued that natural lawyers were looking at what is and drawing conclusions about what ought to be, which he said was impossible.
That's impossible!
Search your feelings. You know it to be true.
But the man we can credit with creating the modern legal world and the underpinnings of the political order is the philosopher Jeremy Bentham. He is most famous with the likes of John Stuart Mill for the philosophy of utilitarianism. It is the greatest happiness of the greatest number that is the measure of right and wrong.
Not bad. Not bad. It's damn good. I'll write it out, think me, then you can all learn it.
But this revolutionary idea would have a cataclysmic impact on the law. He ended the rule of the natural lawyers and created the modern legal world. Although it is often claimed with considerable justification that the true origins of modern legal positivism can be found in the writings of Thomas Hobbes, and that traces can be located in Kant and Rousseau, among others, the creator of more or less modern legal positivism is generally understood to be Jeremy Bentham. Bentham was the first to give us a crisp articulation of the importance of distinguishing between what the law is and what the law ought to be. The first to argue that identifying law requires no necessary recourse to moral criteria, and the first, relatedly, to argue that law is intrinsically and necessarily a social creation with no natural or essentially moral foundations. But although identifying law was thus for Bentham entirely a descriptive project, his legal theory nevertheless contained two different normative dimensions. One of these dimensions, perhaps less important for contemporary academic legal theorists than it was for Bentham the social reformer, was the view that the very purpose of describing law was a normative aspect insofar as the description of law is the necessary precursor of reforming it. Bentham, and to a lesser extent his follower John Austin, was pervasively a social reformer, and his reformist views plainly extended to the legal system he found egregiously defective in countless ways. In purporting to define law in such a way that it could be inspected, rejected, and reformed, Bentham gave us a conception of legal positivism that was at one level entirely descriptive and non-normative, but that, at a more foundational level, was motivated by Bentham's plainly normative desire to use that description as the vehicle for the necessarily normative project of legal reform. Understand that legal positivism is progressive to its core. It's rooted in the idea of reform, that society needs to be reformed, and that includes its laws. But the other aspect of legal positivism is its tendency towards centralization and authoritarianism.
You know it to be true.
The man who invented the term positivism was the French philosopher Auguste de Comte, who ended his days advocating an authoritarian religion of humanity, which may have some resonance in the secular cults advocated today to save humanity or save the planet. But to reform the laws, you have to know what they are. If you could limit the laws only to a single source, man-made laws, and especially the laws enacted by a legislature or parliament, then reform becomes a lot easier. To reform the law, the state just has to pass a new and better law. You see the same movement on the continent. The ideas of the French Revolution were carried forward under the Napoleonic regime, and on the legal front, this culminated in the Code Napoleon in 1804. This is the model of legal codes around the world to this day, within the civil law system, and even in the common law world. Henceforth, all Frenchmen, no matter what community they lived in Paris or Normandy or Nice, would be governed in their civil rights by a single centralized code. There would be no more local customs or traditions or unregulated priests interfering. Power was vested entirely in the centralized French state. Even in common law jurisdictions like the UK, the overriding power of legislation to modify the common law is now accepted as absolute. Bentham was nothing if not eccentric. I'm not sure what this says about the staying power of his ideas, but he had his body stuffed and preserved at his request and put on display so it could be wheeled out to parties. For Bentham, and early legal positivists like John Austin, the theory that best explained law was the command theory. Law is what the sovereign commanded. Bentham is a progressive. He is thinking these laws are going to be reforming society, and these progressive reforms will not be subject to attack. Benthamite thinking infects municipal, state, and federal governments to this day. The changing and wording of laws and regulations and their ever-increasing length and number are invariably justified for their utility. They are tinkering with society, with the sale of property, with rental controls, with property rights, to change people, to change society. They're Benthamites, still believing in progress. The main consequence of legal positivism is an incredible increase in unchecked state power. Legal positivism represented an unprecedented centralizing of power in state agents, never seen before. Rome ran an empire with few laws, leaving most matters to be dealt with locally. Legal positivism was the legal theory that paved the way for the modern total state. Bentham was a utopian rationalist and imagined that bad laws would be identified because people are rational. These liberal Enlightenment ideas persist. The notion that a bad law will lead the people to elect representatives who will then collectively act in the legislature to amend the bad laws, and progress towards a legal utopia will continue. It also assumes you control judges with written laws. The system usually works pretty well in run-of-the-mill litigation, and you get fair decisions all the time, but judges retain enormous powers of interpretation as language is often indeterminate. The more political, the less control words exert on the judiciary. That there exists rational course correction in the system is a tough pill to swallow in our times, where bad laws not only continue to be created, but persist and breed more bad laws, and with each passing year the meddling of the total state in our lives increases. But what is totally absent from this Enlightenment view is an understanding of power. The way power tends to preserve itself and perpetuate itself. We see this mirrored in the explosion of laws, both their number and length. We see this in the power of the executive branch, expanded using delegated authority, and the creation of administrative systems that operate to the exclusion of judicial oversight, like workers' compensation regimes, human rights tribunals, no-fault systems, the abolition of the jury trial. I mentioned Montesquieu and the concept of checks and balances, which was a model for the U.S. Constitution. The executive in the U.S. model is balanced against the legislature or Congress and overseen by the judiciary. This is simplistic and completely ignores the checks and balances that existed before the Enlightenment in a system where law is not concentrated solely in the state. These checks and balances have been abolished by legal positivism. Legal positivism has many proponents, often with dramatically different ideas on what exactly it is. There do seem to be three main externalities that characterize it: the social thesis, the separation thesis, and the thesis of social efficacy. The social thesis is that what is law and what is not is a matter of social fact.
This is this. This ain't something else. This is this. From now on, you're on your own.
A human artifact with criteria that are psychological, pragmatic, economic, and even aesthetic.
Huh? This is this. What the hell's that supposed to mean? This is this.
The separation thesis is that there is no necessary connection between law and morality.
You know it to be true.
The thesis of social efficacy says that the validity of law presupposes that law is socially efficacious, that citizens obey it, and the state enforces it. Otherwise, we have three state actors purporting to impose checks and balances on itself. We see how this works and how state power is propped up, not curbed by this system. Authoritarian regimes, especially in times of crisis, real or imagined, take full advantage of positive law theory. The fact laws are arbitrary, unfair, cruel, or immoral is of no consequence.
You've been uncommonly fortunate, I see, in deathbed confessions.
It's all perfectly legal, I assure you, sir.
States now produce almost spew laws. We are a long way from a people's code you can hold in your hand. The Patriot Act in the U.S., Public Law 107-56, expanded the powers of federal law enforcement agencies investigating cases that involve foreign intelligence and international terrorism. It is 131 pages in length, and it is divided into 1,016 different sections. In Canada, laws to ban firearms are cut and pasted from Google searches, resulting in one notorious case where the Trudeau government banned a coffee shop with a name that sounded like a firearm, and another case where they banned a single-use firearm. But no one questions this was still a law. Another tendency is to include within laws long preambles setting out the state's narrative on the facts, whether true or not. followed by the law itself. Laws are now both the is and the ought. The facts are what the state says they are, bootstrapping the truth. In the popular imagination, words in legislation and in judicial pronouncements have almost a sacred quality. This is what Bentham criticized natural law for doing.
It's all perfectly legal, I assure you, sir.
We have come full circle. Not only has legal positivism vastly increased the power of the state, it has also increased the power of words, of language. Remember the old limitation about Parliament not having the power to make a man a woman, that there were natural limits? There are certainly no such limitations today. The end place of legal positivism and its way of thinking, it seems, is that the words of statutes or the pronouncements of judges are now capable of changing reality itself. If you ask around whether, for example, a man can marry a man or a man declare himself a woman, the answer you are likely to hear is, of course, because the Supreme Court has said so, or Parliament has passed a new law. This is an extraordinary concession to mere words. In fully understanding the success of the liberal or progressive or woke march through society, and the enormous success in spreading the gospel of gender fluidity, and of the supremacy of self over any natural limitations, it is critical to understand the role of legal positivism and its way of seeing the law and reality. This understanding, this underlying conception of what the law is, was, in my view, critical to the near total triumph of the modernist reconstruction of the world.